No, Mr. Dickham.
Thank you. I want to move on and deal with a case in which there is.
Yes, Lord Leggett.
Sorry, just before you move on, Mr. Dicker, do you mind if I ask, just to make sure I've understood the force of or the significance of one of your arguments that you were making before lunch, which is the New York Convention-based argument. Is the point, obviously there's other things being equal, maybe an argument for symmetry between the national law and the international convention, but is the point you're making, or one of the points, that the enforceability of an award at the end of the day will in part, or may depend on whether the arbitration agreement was valid or what its scope was, and it would be illogical if that were determined by a different system of law at each end of the arbitration process, so to speak.
Lord, that is precisely one of our points, yes.
Thank you.
Okay. Yeah, right, Mr. Dickham.
Thank you. Moving on, as I said, I want to turn now to a case in which there is an express choice of law for the main contract. We say that's not this case, but I should deal with the analysis in any event. The question one is asking in this situation is this: if a choice of seat is otherwise a choice of law for the arbitration agreement, does it cease to be one if there's an express choice of law in the main contract, and if so, when? This is ultimately a question of construction, so one can lay down absolute rules. But what we are saying is that one's looking for sufficiently clear wording to indicate that the choice of law for the main contract was indeed intended to apply to the arbitration agreement, despite the fact that it's not the legal system with the closest and most real connection to the arbitration agreement. We say the Court of Appeal was right to conclude that ordinarily one would not construe an express choice of law for the main contract without more extending to the arbitration agreement. I want to deal with the position first as a matter of principle and then look at some of the authorities. It's helpful just to start with one aspect of Chubb's case. Chubb at paragraphs 12 to 58, this is sections B3 to B6, is concerned with arguing that an express choice of law for the main contract may constitute an implied choice for the arbitration agreement. And as we understand it, Chubb accepts that an express choice of law clause in the main contract does not necessarily constitute an express choice of law for the arbitration agreement. The furthest they go is to say it's a strong indication of the proper law for the arbitration agreement. That was certainly how I understood Mr. Bailey to put it yesterday. And that reflects the authorities. For example, South America, Lord Justice Moore-Bigg puts it in a similar way. So one doesn't necessarily assume that an express choice of law for the main contract applies to the arbitration agreement in the same way as one might assume that for any provision of the main contract. As I've said, as a result, phrases like "this policy is governed by New York law" is regarded as inherently ambiguous, not as to which law applies to the rest of the main contract, but as to whether that phrase extends to the arbitration agreement. There's a number of reasons for this, all of which should, I hope, now be familiar. Firstly, the various reasons why a choice of seat is an implied choice of law for the arbitration agreement apply with just as much force. There is an express choice of law for the main contract. So factors like overlap, neutrality, etc. Secondly, indeed, the strength of these factors may be increased where the express choice of law for the main contract is the national law of just one of the parties. The need for a neutral forum for resolving any disputes is obviously likely to be stronger, and if the parties did deliberately choose a neutral forum to resolve their disputes, we say it's reasonable to infer they chose a neutral law to determine questions of validity and scope as well. Thirdly, as I've already submitted, on the other hand, the reasons that prompted parties to choose a system law for the main contract may have little or no application to the arbitration agreement. And fourthly, the express law for the main contract cannot in any event extend the arbitration agreement in its entirety. Certain aspects of it will be governed by English law, given the mandatory and non-mandatory provisions of the Arbitration Act. So the fact that there are inevitably two potentially competing laws means that a choice needs to be made as to which is to apply. All of these are essentially reasons why a express choice of law, although it may naturally apply to all the other provisions of the main agreement, it may be ambiguous as to whether it extends to the arbitration agreement as well. One specific point about the New York Convention in this context, it's a point we make in our written case, paragraph 46, subparagraph 3, page 350 of the electronic bundle. It's a point I think I've probably picked up in my submissions already, but just in case. I've referred to Article 51A of the Convention, the provision that recognition and enforcement may only be refused if the agreement is invalid under the law to which the parties have subjected it, or failing any indication thereon under the law where the award was made. And it's the point about what is an indication, and it's the passage from Mr. van den Berg's work, which I showed you earlier, which I would like to take you back to. It's page 6584 of the electronic bundle.
Yes.
And just if I can start, in fact, at the bottom of 6583, passage slightly earlier than the passage I referred you to before. He says in the last two lines, as regards the second question of which indications are sufficient for constituting a choice of law governing the arbitration agreement for the purposes of Article 5(1)(a, the authors are divided on the question whether, besides the express choice, e.g. this arbitration agreement is governed by the arbitration law of country X, choice can also be implied. The difference of opinion especially concerns the case where a contract included an arbitral clause contains a choice of law clause for the contract in general. Some authors argue that this choice of law clause also applies to the arbitral clause. Others are of the opinion that the choice of law clause for the contract in general is not sufficient as choice of law for the arbitral clause. I then showed you the following paragraphs, but just to remind you of his conclusion at the end of the next paragraph, it is that it would therefore seem that the latter can be achieved only by a distinct express agreement. What he means by that is an agreement that an arbitration agreement is to be governed by a particular foreign law. And he emphasizes obviously the word, I emphasize obviously the word express. And we say that's the prevailing view. One further reference in that respect, you will see at page 1726 of the electronic bundle. It's from an article by Aran van Aranze and Jonathan Hill from the Journal of Private International Law. The passage I wanted to show you is very short, 1726, authors say, first of all, paragraph, that although van der Berg's interpretation of Article 5.1a is not universally supported, it does appear to be correct. The text of Article 5.1a supports the view that Rule 1 is narrow, Rule 2 wider. The word subjected it in Article 5.1a suggests that only an express choice of law directed at the arbitration agreement itself is enough to satisfy Rule 1. And if one then drops down to footnote 76, one can see the various distinguished authors who express that view: Fouchard, Schlosser, Bernardini, and M.L. Moses. There's nothing problematic in the idea that where a particular obligation has a different centre of gravity to the rest of the contract, it may be governed by a different law, even if it's not separable or legally distinct. Through Chips know, it's a concept referred to as dépassage, and an arbitration agreement is probably the paradigm example. Indeed, van den Berg himself suggests that Article 5.1a of the New York Convention is an instance of dépassage, and Hamlin and Talisker has been analysed as such a case. I won't turn up the references, but we give them in footnote 69, page 352 of our case. There are other examples which illustrate there's nothing problematic about this, and we refer to those in paragraph 48.3. There is one maybe worth briefly showing your lordships, and it's the Libyan Arab Bank and Bankers Trust case, decision of Mr. Justice Staunton. You will have that. Starts electronic bundle 3461. I want to show your lordship the set passage beginning at 3479. Um, 3479, letter B, Justice Staunton, under the heading Proper Law of the Contract, says, as a general rule, the contract between a bank and its customer is governed by the law of the place where the account is kept, in the absence of agreement to the contrary. And then dropping to F, Mr. Sumption was prepared to accept the proper law governing the London account was English law from 1973 to December 80. But he submitted that a fundamental change then took place when a managed account arrangement was made. I agree this was an important change, demands reconsideration of the proper law from that date. And then one will hopefully understand a little bit better of what was going on from Mr. Cresswell's at H. Mr. Cresswell for the Libyan Bank submits that then arose two separate contracts, which one related to the London account and remained governed by English law. Alternatively, he says there was one contract governed by English law, or that it had two proper laws, one English law and the other the law of New York. So essentially one had a case here where one contract, two accounts, one in England, one in New York. Miss Justice Staunton's conclusion, you will see over the page 3480 of the electronic bundle, picking it up just between D and E. He says, in my judgment, the true view is that after December 1980, there was one contract governed in part by the law of England and in part by the law of New York. It is possible, although unusual, for a contract to have a split proper law, as Mr. Sumption accepted, and dropping between G and H, that such a solution is not necessarily unacceptable to businessmen, as shown by one of the Australian printed forms of the Charter Party. Adopts it, Mr. Sumption argues that difficulty and uncertainty would arise if one part of the contract was governed by English law, another by New York law. I do not see that this would be so, or that any difficulty which arose would be insuperable. Now, we say it's obviously a different situation, but it's interesting that in that case, single contract governed by two different laws. The reason was because obviously it had two centers of gravity, one English, one New York, and the logic suggested that each should be governed by a different system of law. We say again, two centers of gravity. In this case, one of the centers of gravity was undoubtedly London. That's a reason why London should be the proper law. And obviously you can have défachage if necessary by inference. It's not necessary for there to be an express choice, and that's illustrated by the Libyan Arab Bank case. So if one turns to deal with the authorities, where there is an express choice of law for the main contract, we do this in our written case, paragraphs 49 and 50. Now, we fairly accept that the Court of Appeal was correct. The previous authorities do not speak all with one voice. And it's also true that in a number of them, relevant authorities on the other stream were not cited. But the conclusion reached by the Court of Appeal in relation to this situation is consistent with a substantial number of authorities. Can I just identify a few? Again, just giving you references. C and D. There's an express choice of New York law for the main contract, a London seat. As Justice Cook and the Court of Appeal held English law for the arbitration agreement. XL Insurance, as Justice Toulson, again, express choice of New York law for the main contract, London seat, again, English law for the arbitration agreement. Abuja International and Meridian, as Justice Hamlin, as he then was, it's at page 1855, electronic bundle. Express choice of Nigerian law for the main contract, London seat, English law for the arbitration agreement. Shashua and Sharma, it's Justice Cook, it's electronic bundle 1107. Express choice of Indian law for the main contract, London seat, English law for the arbitration agreement. Karpatsky Petroleum, PJSC Uknafta, that's Justice Butcher's decision, electronic bundle 2404. Express choice of Ukrainian law for the main contract, Stockholm seat, Swedish law for the arbitration agreement. So a run of cases holding that despite an express choice of law clause for the main contract, nevertheless, London seat, English law is the proper law of the arbitration agreement. It's also, we say, consistent with Article 16.4 of the LCIA rules. One just wants to see how that set of rules approaches matter. It's in the electronic bundle 5685. Um, 5685, you'll see Article 16, seat of arbitration and place of hearing. The relevant rule is 16.4. The law applicable to the arbitration agreement and the arbitration shall be the law applicable at the seat of the arbitration, unless and until the extent that the parties have agreed in writing on the application of other laws or rules of law. Such agreement is not prohibited by the law applicable to the arbitral seat. We say, like the New York Convention, when it refers to unless until the extent the parties have agreed in writing, that refers to an agreement specific, not simply a choice of law clause for the main contract. Again, forgive me if I don't take you to it, but in support of that, Wade, Clifford, and Chansey, paragraph 16018, page 6595, the electronic bundle. We accept, as I indicated, that there are, of course, a number of authorities that state a choice of law for the main contract is an indication of the proper law of the arbitration agreement, and Sul America is probably the most obvious one. I've dealt with that decision already. Obviously, one needs to bear in mind that Hamlin and Talisker, C. Darmamont, weren't, for whatever reason, cited in that case. And we say that did affect the reasoning. Justice Morbick proceeded on the basis that choice of seat was only relevant at stage 3 rather than stage 2. And if he hadn't done that, he may well have reached, we say should have reached, a conclusion on the back of stage 2. Well, a similar point can be made about most of the cases that Chubb refers to in this context. Can I just remind you of what they say in paragraph 18 of their written case? It's page 280 of the electronic bundle. What they say in 18 is the principle that an express choice of law for the main contract is an implied choice of law for the arbitration agreement is thus a very strong presumption, which has been applied or stated in cases almost too numerous to cite. They then list a number of cases. I don't unfortunately have time, obviously, to go through those cases. We summarize the position in relation to a number of them in our written case, paragraph 49, note 74. But when your lordships do go through them, in our respectful submission, you will conclude that they are poor support for Chubb's assertion about cases almost too numerous to cite. Just taking a few examples, the Marquis de Ballark, the issue was conceded in that case. In the Union of India and McDonnell Douglas, the issue concerned the curial law and the point wasn't argued. In the Sumitomo and Oil case, for Mr. Justice Potter, the point wasn't argued or finally decided. In Deutz, Mr. Justice Thomas's case, that's an unreported case. Mr. Justice Thomas expressed a preliminary view. Peterson Farms, no reasoning was given and no authorities were cited. If that is the best list can be put together of cases almost too numerous to cite, we respectfully say it doesn't amount to an enormous amount. There are two cases which I do need to deal with, my learned friend referred to. The first is Black Corson, the decision of Mr. Justice Mustill, which you have in the electronic bundles starting at 689. Firstly, Mr. Justice Mustill's analysis, the proper law of the arbitration agreement in this case was obiter, but just looking at what he said, we can pick it up at 696. In our respectful submission, it's not entirely clear what he was doing here, whether this is just an empirical comment about what one finds in actual cases or something different. There's obviously no analysis, no discussion of the authorities. There's no reference to Hamlin and Talisker and C. Darmamont, for example. But on 696, on the left-hand column, As your lordships know, he says, in the great majority of cases, the three laws will be the same, not always so. No means uncommon for the proper law of the substantive contract to be different from the lex fori, and it does happen, although much more rarely, that the law governing the arbitration agreement is also different from the lex fori. So far, one might say, so good. My learned friend referred to the passage at 698. In the right-hand column, Ms. Justice Mustill, having distinguished between the continuous agreement and the reference agreement, then says, about 10, 12 lines down, in the great majority of the cases, the same law governs all aspects of the matter. Again, it's not clear whether this is an empirical statement, what one tends to find, or an analysis of the law, and if so, on what basis. He then says, where the laws diverge at all, one will find in most instances the law governing the continuous agreement is the same as the substantive law of the contract, which is embodied. The law of the reference is the same as the lex fori. Again, it's not clear what the reason he's basing that on is. And then he says, but that the two aspects of the arbitration agreement may on occasion be governed by different law is, in my judgment, an inevitable result of the reasoning adopted by the majority in the House of Lords. And then finally, it's worth noting at 699 that in the first full paragraph, he refers to the continuous agreement, which is obviously what we're concerned with. It says it's unnecessary to reach a conclusion as to the proper law of that agreement. But then if one drops to the last 15 lines of that paragraph, he says, I would, however, be inclined to the view that whatever the proper law of the sale contract the parties had by the inclusion of Zurich, as an invariable locus for the arbitration, indicated a sufficient intention that the law governing the continuous agreement to arbitrate should, throughout the life of the contract, be the law of Zurich. Although he describes that as one of the uncommon cases, the outcome in that case at least is consistent with our case. The other decision was the decision of Lord Mustill in the Channel Tunnel group. I won't take your lordships to it. Similar points can be made about his observations there. And again, C. Darmamol was not cited, and although Hamlin and Talisker was referred to, it was cited on a different and entirely uncontroversial point. Finally, Chubb asserts that the Court of Appeal's view is out of line with the approach taken in other jurisdictions. It asserts that there's a very strong presumption that a choice of law for the main contract is an implied choice of law for the arbitration agreement, and it says that's the position in other jurisdictions. This is paragraph 18, footnotes 24 to 28 of Chubb's written case. I don't have time, again, to go through the various authorities, but we would respectfully say they also need to be treated with a considerable amount of caution. Well, there are also various other jurisdictions which take the same approach as the Court of Appeal. Again, we identify those in our written case, paragraph 51. One which may be worth noting is the position in Scotland. Section 6, the Arbitration Scotland Act 2010, you have in the electronic bundles page 5620. Section 6, dealing with the position in Scotland, says where A, the parties to an arbitration agreement agree that an arbitration under that agreement is to be seated in Scotland, but B, the arbitration agreement does not specify the law which is to govern it, then unless the parties otherwise agree, the arbitration agreement is to be governed by Scots law. So again, a default rule in favour of the law of the seat. And as you'll see from our written case, we say that's also the position in a variety of jurisdictions, including Belgium, China, Japan, Malaysia, Netherlands, Sweden, Switzerland, and the United States. As I've already explained, it's also consistent with the New York Convention. Another passage from Mr. van den Berg, if I may, electronic bundle 6582. Picking it up at the bottom of 6582 under the heading A, law to which the parties have subjected the arbitration agreement, Mr. van den Berg says it has not occurred that a court has found that the parties have subjected the arbitration agreement to a law which was different from the law of the country in which the award was made than the meaning of Article 5(1)(a) of the Convention. And then he repeats the point at 6585 below the heading of B, law of the country where the award was made. It says, as noted before, in the cases in which the validity of the arbitration agreement is judged under the applicable law pursuant to Article 5(1)(a, it has been invariably held the law of the country where the award was made applied to the arbitration agreement. Now, that's obviously Article 5. We say there's no reason why a different conflicts rule should be applied under Article 2, where the court, rather than being required to recognise and enforce an award, is required to grant a stay. Indeed, as your lordships may have noticed, Article 5(1)(a) actually cross-refers to Article 2. We do say in relation to the New York Convention, Mr. van den Berg's views are of some weight. For a number of years, I'm sure your lordships know, he collated the NYC decisions for the ICCA Commercial Arbitration Yearbook. So if anyone was to express a view on the outcome of those decisions, he is, in our respectful submission, as good a source as any. Lords, we were provided with copies of two articles, or it might be more accurate to say draft articles, or yet published articles by Mr. and Mr. Peel. Well, I wasn't proposing to say anything in relation to them. I don't think either materially advances things. The only thing I thought your lordship should probably be aware of, in case you're not, is that Mr. Kennedy refers to having had assistance from Professor Briggs. And I think it's right, your lordships are aware that Professor Briggs is Chubb's expert in this case in Russia. I just leave your lordships with that. So in conclusion, we say whether an express choice of law will amount to a choice of law for the arbitration agreement is ultimately a question of construction. But for the reasons we've given in our submission, the Court of Appeal was correct to say that ordinarily it will not. Well, my next task is to deal with the facts in this particular case. Enka submits in this case that the choice of seat amounted to an implied choice of law for the arbitration agreement, and there's nothing to displace this. And 3 points. Firstly, the main contract does not contain any express choice of Russian law, and that's an end of it if we're right. Secondly, in any event, it doesn't contain any clearly demonstrated or implied choice of Russian law. And thirdly, even if it did contain an express or implied or clearly demonstrated choice for the main contract, that didn't amount to a choice also for the arbitration agreement. Can I deal first with the point that there's no express choice of law for the main contract. This is what the Court of Appeal held in our submission, plainly, rightly. Chubb accepts there's no express governing law in classical form. There's nothing of the form. This contract is governed by Russian law. Its case, as we understand it, is that an express choice of law is nevertheless discernible from Articles 1 and 45 of the main contract, read together with the definition of applicable law in attachment 17. I wanted to show your lordship those provisions. My learned friend dealt with this very shortly. So picking up the contract, which your lordships have, it's in the electronic bundle starting at 485. Just looking quickly at the provisions that Chubb refers to. The first is Article 1, which you'll see on page 486. Article 1, terms and definitions. The terms used in this agreement shall have the definitions set forth in attachment 17 to this agreement. Article 45 you will find at page 582. I'm sorry, page 570. It's headed at 569, Article 45, attachments, page 570, Article 45.1. The attachments listed in this article must be considered inseparable parts of this agreement. For the purposes of interpretation, the priority of the attachment shall be in accordance with the following sequence. Then listed, and attachment 17 is one of the ones listed. You can see that on page 571. Then if we go to two definitions in attachment 17, the first is applicable law 593, page 593. Applicable law is defined as law of the Russian Federation, including legislation of the Russian Federation. All regulatory legal acts of the state authority, federal bodies, state authorities of the constituent entities of the Russian Federation, legislation of the constituent entities of the Russian Federation, regulatory legal acts by local authorities, and any other applicable regulatory legal acts. The other definition is mandatory technical regulations, which you'll have at page 591. And one can see the flavor of that fairly quickly. It includes the following regulations applicable in the Russian Federation, and then A through to H are listed. And it then says in every separate case specified in clauses A to H, to the extent specified by the applicable law, including orders or requirements by the government authorities issued according to the applicable law, mandatory for observance by the contractor when performing works. Now, we say one thing is plain, none of those provisions are a governing law clause for the main contract, let alone an arbitration agreement. That's not necessarily an end of things. One has to see how and why the concept of applicable law is used in the contract. And at this point, we say the concept of applicable law is a very familiar technique to international construction lawyers. The purpose of such provisions is to identify the laws and regulations which apply to the various elements of the construction project and make compliance with them an express obligation of the contractor. So one has a situation, classic case, the employer is the owner of the project or the tenant of the site, may be liable for any failure by the contractor to comply with such laws and regulations, and the intention is to provide the employer in such circumstances with a contractual remedy for such failures. So they're not governing law clauses. What they are clauses which impose additional obligations on contractors by reference to applicable law. And we say this is perfectly clear from the textbooks. We referred the Court of Appeal to one by Baker dealing with FIDIC contracts. Can I show you what we showed the Court of Appeal? It's in the electronic bundle, starts at 5730. One can see 5730, it's a book about FIDIC contracts by 4 individuals who one sees from 5732 are at White and Case. Now, passage I want to show you, we start at 5734. The heading applicable laws and permissions. I'm dealing with this as quickly as I can. Laws relevant to the contract. 2.125. The FIDIC forms are intended for use in international construction projects. Then dropping to the last 3 lines, that paragraph. This internationality gives rise to some potentially complex issues relating to the law or laws that are applicable or relevant to the contract. 2.126, the first legal system that needs to be considered is the law that governs the contract. This law will primarily determine the rights and obligations of the parties under the contract. However, local laws, that is laws where the work is carried out, will apply to some of the actions and obligations of the parties, even if different to the law governing the contract. These local laws are often either mandatory as a public policy, and some examples are given, or apply because of the physical location where the work is being performed, particularly the site. And the last 3 lines, where the contractor is responsible for the design of the works, the contractor is required to ensure the permanent works comply with applicable laws. There's then a number of sections. Just seeing the structure, if you go to 5735, there's a heading law governing the contract. And then, just so one sees the shape of it, one goes to 5737, there's a heading compliance with applicable laws. So the distinction is drawn. If we go back to 5735, 2.127, this is all fairly obvious stuff. Subclause 1.4 of all of the FIDIC forms, it's the governing law clause, provides the contract should be governed by the law or other jurisdiction stated in the relevant contract documentation. 2.128, the governing law will usually be the law of a country, state, or jurisdiction. This will determine the validity and enforceability of the contract and its terms, the rights and liabilities of the parties, and the legal remedies as a consequence of breaches of the contract. And then 5736, next page, paragraph 2.133. Despite the fact it is intended under subclause 1.4 that the governing law will be stated in the relevant contract document, there is no express default provision specifies the governing law if the parties fail to state a law. The governing law is not chosen. This can give rise to real uncertainty later as the laws governing the contract. I may want to note 2.134, they all provide, all versions of the book provide for arbitration under the ICC rules. And then 5737, the other section, compliance with applicable laws. 2.140, specific aspects of the parties' performance of their obligations under the contract may be subject to laws of countries or jurisdictions other than the governing law, including the law of the country where the site is located. Parties will therefore be under a general obligation to comply with these other laws. However, the FIDIC forms, as with many other standard forms, bring the contractor's compliance with these laws into the confines of the contract. And then the reason is explained. This can be explained by the fact that the employers in particular may be liable for the contractor's failure to comply with the relevant laws due to the employer's status as owner or tenant of the site or ultimate owner of the work. By placing on the contractor a contractual obligation as between the parties to comply with these laws, a failure to comply will be a breach of contract for which the employer may generally be entitled to damages or another legal remedy. And finally, if we just pick up 5738 under the heading Laws, 2.145, the FIDIC forms adopt a general and wide definition of laws, namely all national or state legislation, statutes, ordinances, and other laws and regulations and bylaws of any legally constituted public authority. Laws as defined are therefore not restricted to any particular country or jurisdiction. There are similar discussions in other textbooks. We've included 3. I won't show your lordships the extracts. I don't have time just to identify them. Firstly, Bailey, Construction Law, Electronic Bundle 5718. Secondly, Glover and Hughes, Electronic Bundle 6083. And thirdly, Hughes, HUSE, Understanding and Negotiating Turnkey and EPC Contracts, which deals with other standard form contracts. This is Electronic Bundle 6097-98. And there's a list of standard form contracts: NEC, ICHEM-E, AIA, DBIA, ENAA, EMP, EPC. I won't pretend to understand what those are. The general point is applicable law provisions are very familiar to international construction lawyers. My learned friend said virtually nothing about the significance of this material, other than to say that the contract is not a FIDIC contract. Our response is that the rationale for the applicable law clause that I've shown your lordship isn't limited to FIDIC. It's generally why one finds such a clause in any international construction contract, and my learned friend hasn't identified any reason for supposing that the parties in this particular case had some different rationale in mind. And the role of the concept of applicable law in this contract is entirely consistent with its treatment in the textbooks. As we set out the relevant references in our written case, paragraph 56, subparagraph 2, footnote 84, page 356 of the electronic bundle. Can I deal with these very quickly? If your lordships go back to the contract, which you have in the electronic bundles 485 and onwards, just showing your lordships the shape of this. If we go back to 486, below Articles 1 and 2, your lordships have seen Article 1, there's Article 3, obligations of the customer. 3.1, just to show your lordship how this works, at 487, this is about right of access to the construction site. And at the top of 487, it says, the exercise of the said right of access to the construction site by the contractor shall be contingent on proper fulfilment by the contractor of the terms of this agreement, including with regard to occupational safety, safety practices and environmental protection, and all provisions of applicable law. Similarly, 3.4 one goes to 488 over the page. It's the top sentence. The contractor shall be responsible, if required under applicable law, for registering the construction equipment. So Article 3, obligations of customer, but the use of applicable law in that context effectively imposes a condition on the contractor. There's then in Article 4 a whole series of provisions that use the concept of applicable law. Again, just showing you at 489, Article 4, obligations of the contractor. Contractor shall ensure performance of the work in accordance with A, the requirements of this agreement, including references to the non-mandatory rules of applicable law, B, applicable law, including the mandatory technical rules constituting a part of such applicable law, C, an implied covenant of good faith and dealing. So what then follows is a whole series of provisions saying, for example, the contractor is required to obtain permits required by applicable law, required to comply with all safety requirements stipulated by applicable law, ensure emissions within the range permitted by applicable law. I'm sure your lordships get the flavour. The short point is all of these provisions are entirely...
Yes, Lord Burns.
Oh, I'm sorry.
Yes, I'm just trying to get precisely clear in my mind then what the understanding of applicable law is. If we sort of translate it into concepts that at least I might be more familiar with, I think you're telling me that applicable law is not what we mean by governing law. It's something like, is it, incorporation by reference? What is it?
That is exactly the point. It's not governing law, it's incorporation by reference. Obviously, it would be impractical to incorporate the text of all applicable laws into the contract. You'd end up with an encyclopedia rather than a contract. It also wouldn't work because it wouldn't deal with the fact that the contractor is obliged to deal with changes in respond to changes in applicable law. But your lordship has the point, absolutely spot on.
Thank you very much.
All of these provisions, we say, are consistent with the explanation for applicable law clauses in the textbooks. They're almost all concerned with obligations of Enka as the contractor, not of the customer. Secondly, they're almost always used to refer to obligations arising under the general law, not arising under the contract itself. Indeed, some expressly distinguish between contractual obligations and obligations under applicable law. Lordships will see in due course Article 36.1 deals with requirements for work quality at page 553. Thirdly, the definition of applicable law is not limited to Russian law in the same way as it's not in the context of FIDIC contracts. Your lordships remember at the end of the definition there's a reference to and any other applicable regulatory legal acts. So if it happened that there was some other regulatory provision which the parties were required to comply by, this becomes an obligation of Enka in accordance with the articles. Fourthly, even where applicable law does refer to Russian law, lordship should note it may be overridden by more stringent international performance standards used by experienced international contractor organizations. That's the effect of Articles 4.1c, 4.2, and the definition of good faith in attachment 17. So in other words, they're not necessarily the most onerous obligations in any event. If international performance standards are more onerous, then you have to comply with those rather than complying with applicable law. In any event, obviously, none of these provisions has any perceivable relevance to the distinct obligations in the arbitration agreement. So for these reasons, we say there's no express choice of law for the main contract, no governing law clause in classic form, and Articles 1, 45 and Attachment 17 do not amount to such a clause. The Court of Appeal was therefore correct, and we say in our submission that's the end of Chubb's appeals in this case. But we go further to say, nor is there any clearly demonstrated choice of law for the main contract under Article 3 of Rome 1. My learned friend is right. The law isn't, it appears, controversial between parties. He referred to the decisions in Lawler and Sandvik Mining. The Lordships have that, 3381 and following, and the decision of Julia Dyer sitting as a deputy in GDE and Anglia Autoflow, page 3031 and following. I won't take your Lordships to them. The 2 points are, first, the choice is only clearly demonstrated if the only reasonable conclusion to be drawn from the circumstances is that the parties should be taken to have intended the putative law to apply. And secondly, the court should not infer a choice under Article 3 merely from the fact that there are considerations which link contract with a particular country. Now, so far as Chubb's case on clearly demonstrated is concerned, it relies on two main points. Firstly, again, Articles 1, 45 and Attachment 17. These provisions don't assist Chubb for the same reason they didn't assist it in the context of an express choice. The concept of applicable law is not there to identify a governing law, either expressly or impliedly. It's there to impose on Enka, as contractor, an obligation to comply with laws and regulations of any jurisdiction that may apply to the project. Secondly, Chubb refers to a list of various factors relating to the parties and the contract. The various factors referred to by Chubb do not, in any event, only refer to Russia. We deal with this in our written case, paragraph 63, subparagraph 1. There are a number of factors that point to Turkey or elsewhere. And obviously the fact that the seat of arbitration is London is also a factor of pointing away from Russia. There is no governing law clause in the contract. There's another reason why we say Chubb cannot establish, it's clearly demonstrated that the parties intended Russian law to apply, and that's simply because there's another perfectly plausible explanation as to why there is no governing law clause. Simply that the Russian customer and the Turkish contractor are unable to agree expressly on what that governing law should be, and nor, as a result, they share a common intention that's capable of being clearly demonstrated. Not remotely surprising in the context of a construction project like this. Now, assume, however, that I'm incorrect about this, and that the arbitration agreement is somehow, by one route or other, governed by, otherwise governed by English law. We say there are two further reasons why the proper law of the arbitration agreement must, in any event, be English law, and these are effectively fallback positions. The first concerns something called the validation principle, and I want to explain what this is, what the basis of it is, and why it's relevant in this case. Chubb accepts in its written case that even if there is an express or clearly demonstrated choice of Russian law for the main contract, it would not apply to the arbitration agreement if this would or might mean that the arbitration agreement was invalid. And that's known as the validation principle. And the basic idea is the parties have clearly agreed to arbitrate, and it would not make sense to conclude that objectively they nevertheless intended a foreign law to apply if that foreign law would effectively negate the agreement. It's a principle which has been applied in a number of cases. One saw a reference to it in effect in Lord Herschel's speech in Hamelin and Talisker, and it's referred to in, obviously, in Sul America. Again, so you have the references, paragraphs 26 and 31, pages 1142, 1144 of the electronic bundle. The underlying logic of the validation principle, as I say, is it's essentially a principle of construction. One assumes that the parties intended their agreement to make commercial sense. In the case of ambiguity, one's entitled to resolve any ambiguity in a way which does rather than doesn't make commercial sense. And obviously one's assessing this objectively. It's not actually looking at the subjective intentions or of the parties. So if one has a situation in which the parties have agreed to arbitrate, and there's a question of whether or not their arbitration agreement is governed by English law and foreign law, if the arbitration agreement would be upheld under English law, but negated under foreign law, commercial common sense would suggest that having agreed an arbitration agreement, objectively, they must have intended it to be governed by English law, not foreign law. So it's essentially, although referred to as the validation principle, it's essentially an aspect of a question of construction. Now, and as I say, it features in the cases, not merely in the English cases. It's apparent in lots of the commentary. One thing your lordships will note when you read the various commentary is a number of the commentators actually seek to elevate the validation principle into effectively a single way of resolving matters in difficult cases. Now, Chubb and I'm reminded, as the authorities establish and as Sul America indicates, you don't have to establish that the arbitration agreement would be invalid under the foreign law. It's sufficient if there is a risk that it would be. Again, same common sense rationale applies. The parties wouldn't risk invalidity by having a foreign law apply. Now, Chubb contends that the validation principle does not apply in the present case. We respectfully say it plainly does. And the reason for that is the Russian court has held in different proceedings that an arbitration agreement which provides for arbitration in accordance with ICC rules, essentially an agreement of the same form as that in this case, is ambiguous and therefore unenforceable as a matter of Russian law. Can I show your lordships the judgment, which is in the bundles? It starts at 5448, and the passage I want to show you is at 5454. So starting at 5448, so your lordships can see the case. It's a decision of the Commercial Court of Moscow. It was decided on 8th of February 2018, and the judge is identified at the start. If one then goes on to 5454, having dealt with one issue, at 5454, the court turns to a second issue. At the top of the page, the judge says, besides the above, the court upholds the defendant's argument that the International Arbitration Court, International Chamber of Commerce, is not competent to hear the dispute. According to paragraph 15.3, appendix 3 to the contract, any dispute not settled amicably must be finally settled in arbitration, finally settled according to arbitration rules of the International Chamber of Commerce. Dropping 4 paragraphs, beginning, the court believes that based on the contract terms and conditions, the parties did not designate any particular institution to be considering the dispute. In other words, they identified the rules, not the institution. Judgment continues, the contract does not contain any direct and written consent of the parties to have all disputes settled in the International Arbitration Court, International Chamber of Commerce, even though such wording as in international arbitration meets all the criteria for its classification as an ambiguous wording, can be regarded by either party as the entitlement to approach to another court of a similar name, which suggests the International Arbitration Court, the International Chamber of Commerce, does not have the expressly stipulated competence to settle this dispute. So in other words, it's not enough, apparently under Russian law, to say that you want arbitration in accordance with ICC rules. What you have to do is actually identify the body to determine that. And over the page 5455, paragraph 2, this violation is, according to the above provisions of the Convention and Russian law, in itself a sufficient reason for denial of the motion to recognize and enforce a foreign court decision, because the foreign court decision contradicts the public policy of the Russian Federation. There's an article by Deboise and Plimpton that refers to this decision. I wanted to show your lordships at 6817. At 6187, the briefing note says, a judge of the Supreme Court of the Russian Federation recently upheld decisions of the lower courts refusing to enforce an ICC award on the grounds that the grounds of the underlying ICC arbitration clause did not constitute an enforceable agreement to submit to arbitration under the ICC rules. At the end of that paragraph, Russian courts found the arbitration clause did not meet the principles of certainty and enforceability, and the ICC, International Court of Arbitration, therefore had no jurisdiction over the dispute. And the briefing note continues saying, the president of the ICC, Alexis Moury, sent a letter to the Supreme Court expressing serious concerns over the approach the Russian courts have taken with respect to what on the face of it appeared to be a standard ICC clause, asking the chairman of the court to clarify the position. And the note says, as far as they're aware, no response yet. Now, rather surprisingly, Chubb doesn't refer to this decision anywhere in its written case. It's surprising because in November 2019, it specifically relied on this very authority in Russia to contend that clause 50.1 of the contract is enforceable. And if I can show your lordships that, it's in the appendix. At page 778. At 777, you'll see the heading to the, there's a reference to objections of LLC Chubb Insurance Company to on leaving the claim without consideration. I was concerned with Enka's application to dismiss. And then if one goes to 778, at the bottom of the page 5, arbitration clause contained in paragraph 50.1 the contract agreement, as well as the contractual provision of clause 7.5 of the assignment agreement, shall not comply with the international commerce guidelines which threaten the dispute resolution process of the parties under the contract. And then if one goes to 788, there's a section 2 beginning at 4.5. The arbitration agreement which Enka responds to not correspond to the standard International Chamber of Commerce clause, contains unclear wordings that may make it difficult to threaten dispute resolution process. And at 4.8 on 789, Chubb essentially adopts the points made by the judge in the Russian decision I just referred to your lordships to. Now, that contention has obviously not so far succeeded. I wasn't clear from my learned friend whether he was saying Chubb has abandoned that contention in Russia, or if so, when, and the position is slightly unclear, but that doesn't matter. There plainly is a potential issue in Russia as to whether or not an ICC arbitration clause is valid. It appears to have been a point sufficiently worth running. Chubb did, in fact, run it in this case. And we say in those circumstances, there plainly is a risk that the Russian court, even if it hasn't done so already, will follow the Russian decision and reach a similar conclusion on appeal in this case. And in those circumstances, judging the petition objectively, did the parties, when they agreed to arbitrate, intend to do so in accordance with a proper law that might render their agreement nugatory? We say no. Lord.
Yes, Lord Legate.
Does it make any difference that the agreement in this case was made long before this recent decision of the Moscow court, or you say one should presume that it was equal uncertainty when it was made?
Lord, one, equal uncertainty when it's made. Two, I'm proceeding on the basis that Russian decisions, like English decisions, are effectively declaratory of the position rather than making law. On that basis, this has been the position in Russia, and it was at the time that the agreement was made. Lord, the point also goes slightly further. One of the points the Court of Appeal refers to is involves the Fiona Trust. Chubb obviously argued in Russia that the arbitration agreement doesn't cover joint liability in tort, where there are multiple defendants. This argument was upheld by the Russian judge at first instance. Again, we say this a similar approach to construction applied if the House of Lords was right in Fiona Trust to say that as a matter of general commercial common sense, not limited to English law, businessmen would usually intend all of their disputes to be decided by arbitration. On that basis, it doesn't make sense to you subject the arbitration agreement to a foreign law, which will have precisely the opposite effect. The consequence of the judge's decision in Russia is that in this situation, because there are multiple defendants, the arbitration agreement doesn't work. Enka can't rely on it, and Enka has to litigate in Russia. The other default point, second reason why the arbitration agreement is in any event governed by English law, concerns the pre-arbitral procedure in clause 50.1 of contract. And as your lordships know, there are two parts to clause 50.1. It's an obligation to make good faith negotiations to resolve any dispute or disagreement between the parties, and there's also an arbitration agreement. And we say, essentially for the reasons set out by the Court of Appeal, the first part can't sensibly be governed by Russian law. If it were, then on Chubb's case, management would be on an obligation to make good faith negotiations to discuss and resolve some types of claims, but not others, depending on their legal classification of those claims under Russian law. So if the Russian first instance judgment is correct, and arbitration agreements don't apply to tort claims involving multiple parties, if one takes the same approach in relation to the pre-arbitral process, that means the parties were under an obligation to discuss and try and resolve their disputes, but not those disputes. Now, quite how a businessman is meant to settle and decide on what sum, if any, to pay when he's only dealing with one out of a number of interconnected disputes is not clear. It doesn't make commercial sense. Management would need to identify those claims that were covered by the obligation and those that were not, and discuss and only resolve those that were covered, at least so far as 50.1 required them to do so. So we say the only sensible approach to the pre-arbitral procedure is that the parties must have been intended to discuss and try and resolve all their disputes. That presumably was the point of this clause. And that must also be true of the arbitration agreement. And if it is also true of the arbitration agreement, that agreement must be governed by English law, because Russian law produces a different result. I wasn't proposing to say anything in relation to Rome 1. We've dealt with it in our written case. It's not in our submission a freestanding point, and there's nothing further I wish to say. We do submit that for all these reasons, the arbitration agreement in this case is governed by English law. And if that's correct, it is common ground that the appeal should be dismissed and issue 3 does not arise. That then takes me to issue 3. And I wonder if I may just ask, so I know how long I have left. Mr. Landau, for good reason, went slightly longer in his submissions. I calculated by some 7 or 8 minutes, but I'm happy to leave it at 7. I'd assumed that he was doing so on the basis that would be eating into his reply rather than my submissions. On that basis, I was hoping to be permitted to finish 7 minutes after 3:30, but I'm in your lordship's hands. I have issue 3 still to deal with.
Yeah, well, let's try for 5 minutes, shall we?
So issue 3 only arises if the arbitration agreement is governed by Russian law, and we say it doesn't arise, but I need to say something about it. The argument is put by Chubb on 2 bases: forum non-conveniens and comity. Justice Andrew Baker decided the case, as you know, on his own motion on forum conveniens grounds. Chubb's case before him, at least, was based on comity. Lords, given that your lordships, I'm sure, are familiar with the issues on this aspect of the appeal, and we deal with it in detail in our written case, I'm going to deal with it very shortly. I I wasn't proposing to say anything in relation to forum conveniens. We adopt the reasons given by the Court of Appeal for rejecting that approach. Chubb itself deals with it very shortly indeed. It's less than a page in the electronic bundle, page 318. So I was going to turn and deal with comity. Unlike the forum conveniens argument, Chubb does not contend the English court doesn't have jurisdiction to determine the claim. The argument is merely that it would be a breach of comity to grant an anti-suit injunction when one gets to the stage of remedy. We say Chubb's argument is illogical. Firstly, it doesn't challenge the decision of the House of Lords in the front coma. It therefore accepts parties submitted to the jurisdiction of the English court to determine whether to grant an anti-suit injunction, and in that context to decide the questions of scope and breach. So you can decide scope and breach. Secondly, it accepts that if the arbitration agreement is governed by English law, the court can determine whether there is a breach and grant an injunction. So it accepts no issue of comity arises in this situation. The arbitration agreement is governed by English law. You can grant an injunction to restrain foreign defendant from suing foreign proceedings, and there's no question of comity. Thirdly, we say the position does not change merely because the arbitration agreement is governed by Russian law. The English court doesn't offend comity merely by deciding on the effect of a Russian law arbitration agreement. The fact that the Russian court may objectively be better able to decide on the scope of the agreement is irrelevant. Parties have agreed that the English court is to decide this issue, and deciding that issue does not of itself infringe comity. For example, if the English court were to grant declaratory relief or award damages having construed a foreign arbitration agreement, it couldn't possibly be suggested that this infringes comity. Now, that's why Chubb's argument is illogical. Why is it wrong as a matter of law? Well, we say first and main error is that it fails to distinguish between contractual and non-contractual anti-suit injunctions. In the context of contractual anti-suit injunctions, the authorities establish that considerations of comity do not arise. This is because the court is not doing anything more than restraining breach of a particular kind of negative contractual obligation. I take that phrase from a case, Clear Lake Shipping and Xiang Da Marine, paragraph 18.1, a decision of Andrew Burrows, QC as he then was. The reference in electronic bundle is 2468. In such cases, the true role of comity is to make sure the parties' agreement is respected. That's what Lord Justice Longmore says in the OT Africa case, and it's echoed by Lord Justice Morbig in the use of Sebliu. It's worth saying that in this respect, cases prior to the angelic grace should be approached with caution. Can I show your lordship Chubb's written case, paragraph 101, page 312 of the electronic bundle. This is essentially the only case they cite in their favour on this. In 101, on page 312, they say the significance of the proper law in this contract was recognised by Mr. Justice Coleman in Sakana Industries, a case concerning a dispute under a contract governed by Florida law, which included an arbitration agreement with an English seat where an anti-suit injunction was refused. Justice Coleman treated the fact the contract was governed by Florida law as a strong argument against the grant of an anti-suit injunction. That case was decided in 1994. It's worth looking to see how it's been described since. Firstly, in AES, in the Court of Appeal, it's page 1889 of the electronic bundles. Um, 1889, Lord Justice Ricks, in the right-hand column, 52, he refers to Sakana, and he summarizes the judgment at 53. It's the last 5 lines of 53 I wanted to show you. This was before the Angelic Grace had liberalized the grant of anti-suit injunctions in support of arbitration agreements. The other reference is AES in the Supreme Court, electronic bundle 635. This is Lord Mance, 635, paragraph 25. It says, in the 1990s, it had come to be thought that the power to injunct foreign proceedings brought in breach of contract should be exercised only with caution, because English courts will not likely interfere with the conduct of foreign proceedings in a foreign court, e.g. Sakana Industries. But in the Angelic Grace, dropping 2 lines, the Court of Appeal held, citing Penna Copper and other authority, the courts ought not to feel diffident about granting an anti-suit injunction if sought promptly. Lord Mance then elaborates on that in the following paragraphs through to 28. Lord, yes.
Yes, Lord Dean.
Before you run out of time, Mr. Vicar, I'm particularly keen you should respond to what I took to be Mr. Bailey's essential submission, which is that there's always a discretion in the court, and that there may be a case, which he would submit this is, where the question of foreign law may be an arguable one, and it might, as a matter of practical common sense, be better as a matter of discretion to let the foreign court decide it, if you think it's going to be capable of giving an impartial decision, rather than for this court to decide that it knows better what Russian law is. That was took to be his main argument.
And, my lord, the short answer to that is the parties have agreed arbitration. They have agreed to supervision, support, and the exercise of anti-suit injunctions, if necessary, by the English court. They have done so to ensure that they are insulated from the Russian court. Lord, your lordships, with the greatest respect, would be trampling upon that agreement if you nevertheless shipped this dispute off the Russian court to decide. The whole point about coming to London was to ensure that the arbitration agreement would be construed by a neutral body, either the arbitral tribunal or, if necessary, by the English court. So whilst one might accept in another case, absent agreement, one might look at the position and say, we've got an issue of Russian law, let's leave it to the Russian court. They're more used to deciding issues of Russian law. We say that's been overridden by the agreement of the parties. And if one looks at the Angelic Grace and all the other authorities, this distinction is not drawn in any of them. The statements of principle are all expressed generally. It's true in the Angelic Grace there was a reference to the fact that the arbitration agreement in that case was governed by English law. Lord Justice Leggett said that's a paradigm case. There is no indication whatsoever of this distinction previously being drawn, and in our respectful submission, it would be wholly contrary to principle and the parties' agreement to do so. Finally, my own friend didn't, I think, actually identify any reasons why this case in particular should go off to Russia. He was asked, is it a consequence that every issue of foreign law would go off to the foreign court? He said no, it depends on the facts, but he didn't identify any reasons why this case was special on the facts. I'm conscious I've used up the 5 minutes. Can I just make one separate point
Yes.
before I finish? And it's simply this. We understand, for your lordships, timing, that the Court of Appeal in Russia is likely to deliver judgment on the 28th of October. And obviously, a decision of your lordships in advance of that, if it were to require Chubb to withdraw the appeal, ideally would need to be sufficiently in advance to enable that to occur before judgment was handed down. But I thought it right to mention to your lordship that's the date that we understand the further appeal may be decided in Russia.
Yes, Lord Barrows.
Just the point of clarification there, when you say judgment delivered, do we have dates for when the appeal is to be heard?
Well, I understand, and no doubt we can give you chapter and verse on this, but I understand it. That's the two are the same.
Thank you.
Yeah. Well, yes, Lord Leggett.
Sorry, one more question, Mr. Vicar. If we were to decide that it was Russian law that applies, what are you inviting us to do? I in your case, suggest send it to the arbitrators nevertheless, but the logic would seem to be to send it to the commercial court.
Well, Lord, we say send it to the arbitral tribunal. That's the tribunal the parties agreed. An arbitral tribunal has been constituted. It's Lords Hoffman, Mance, and Michael Brindle. It's a pretty high-powered tribunal. We say that's the sensible course. This isn't a case in which it could easily be sent back to commercial court, at least in the sense that Mr. Justice Baker didn't reach a decision on Russian law. The issue would effectively have to be heard afresh, and we would respectfully suggest by another judge as well. So yes, we would say interim relief in the meantime, and for the matter to go off to be decided by the arbitral tribunal.
Well, on your request that we, at least the implication from your latest submission is that you would like a judgment in this case before October. Well, we have listed the case fairly expeditiously. I'm afraid we can't promise anything in relation to the delivery of judgment, but we have heard what you've had to say about that. Thank you very much indeed, Mr. Dicker. Now, Mr. Bailey.
Much obliged, my lord. Can I start just dealing with those last 2 points? Firstly, my understanding of the position is that the first hearing of the appeal is scheduled for the date in October that my learned friend gave. But you should realise these two important points. Firstly, the parties have reached an agreement in the terms of undertakings that my clients have given to your lordships. I can't give you the reference immediately, but I believe it's in the appendix documents.
Yeah.
The first of those undertakings is to agree to adjourn the hearing in Russia. So there's absolutely no threat from what my learned friend says that there's going to be a judgment announced on that date in October. I suppose it's theoretically possible, but it's an unrealistic one. In my respectful submission, it can be dealt with by way of the undertakings that we've agreed and given to your lordship's house. The second point, in terms of the remission to the tribunal point, my lords, that is both logically and legally impossible. It's legally impossible because it effectively amounts to my own friend saying, I want a Section 9 stay of my own action. And of course, there is no Section 9 application. But secondly, the logic of it would require the arbitrators to hear fresh evidence of Russian law to reach a conclusion on their jurisdiction, and then for the court to have to review it all over again on Section 67. And my lord, it makes no sense at all. The choices are, in my respectful submission, either, as we submit, allow the Russian Court of Appeal to decide a difficult point of Russian law, or to remit it to the High Court and allow the High Court either to follow the existing decision of the Russian court on the very point it has to consider, or to hear fresh evidence or additional supplementary evidence to that already heard and reach its own decision and stop the Court of Appeal in Russia from deciding. Or you have the Judge Rakoff approach, which is to retain jurisdiction over the anti-suit action just in case something goes wrong in Russia, but to allow the Russian court to decide the point on appeal, and then for the English court, assuming nothing's gone wrong, to endorse it. And in that sense, ultimately, the English court is simply making the decision, which is what my own friends make, but with the assistance, essentially, of the Russian court on the key point of Russian law. Well, those are the practicalities. I do, though, in the time I've got, want to deal with some more substantive points. Firstly, and perhaps I can take these fairly quickly, but there are quite a number of them. The first point is Lord Burroughs' question, which is, what is the proper law of a jurisdiction agreement in a contract governed, let's say, by Russian law? Well, that's a question of construction, so of course it depends on the circumstances of every case. But the starting point is expressed by Dicey in paragraph 12-103, page 1463 to 1464 of the electronic bundle, which is the effect that normally a jurisdiction clause is governed by the proper law of the agreement of which it forms part. So in other words, it's wholly consistent, we would submit, with the arguments that I advanced yesterday. Now, my lords, in terms of trying to dissect the errors in my learned friends' submissions, I can't do any more than highlight some key ones, which I'm going to endeavour to do. The first, and perhaps the most important, is this: that throughout my learned friends' submissions, there was a repetition of the mantra that a mere choice of seat is an implied choice of law. A number of short points to make on that. He says the proposition is derived from Tunisienne and from Hamlin, and for reasons I've already explained yesterday, we would submit that those authorities give no support to that proposition. Secondly, the correct position is explained by Lord Justice Steyn in the Star Texas at 4418, the bottom of page 4424 to the top of page 4425, where he says explicitly, even an express choice of jurisdiction does not by itself give rise to an implied choice of law. Now, my own friend didn't even address that case in his submissions. What he rather sought to do was to rely upon Habas, and in particular paragraph 102 of my Lord Hamlin's judgment in that case. But as I submitted yesterday, what Lord Hamlin said in that case was entirely consistent with the Star Texas, and also consistent with the Egon case, a decision of Mr. Justice Clark that Lord Hamlin referred to. Now, we didn't have time to go to that case yesterday, but it's very important, and it's page 2899 of the bundle. I'm sure you will look at it. But there is one particular passage which we perhaps ought to turn up, just to make the point I'm making good. It's at page 2908, so 2908 of the electronic bundle.
Yes.
And it's the right-hand column, and it's Mr. Justice Clark's then was referring to a passage from Dicey, and what they say there is, secondly, an arbitration clause. Well, let me rather than read it all out because there isn't time. The key part of the Dicey passage there is the fact he's saying that whether or not an arbitration clause has any basis as an inference of proper law will depend on the circumstances. That's what he says.
Yeah.
And the relevant Dicey extract in the current edition is at page 1477 of the electronic bundle, so you can find it there. But the important point is, looking at that Dicey passage from Dicey, the last sentence on 2908 is important. It says, although it says it. Thirdly, the indication of an implied choice of law will be much weaker where the arbitration clause, although it specifies a place of arbitration, does not provide for a method of identifying the arbitrators except through an appointment by an international arbitral body such as the ICC.
Yes.
Now, of course, that is the very point that the learned judge below relied upon in his judgment, paragraph 60 to 65, page 447 of the electronic bundle, as a basis for saying that in this particular contract, when the arbitration clause is construed within the context of the contract as a whole, it is not an indication of an implied choice of proper law. And that's entirely consistent, we would submit, with Egon, with Star Texas, with Habas, and also with the passage my Lord Sales took my own friend to this morning, which was 16019. And my own friend gave the answer of, well, look at footnote 42. And when you go back to that passage from the transcript, you'll see that footnote 42, the very first case cited in that footnote is the Egon case, which I've just referred to and you have open on your screen. So, Lord, that's the very first failure, if I may say so, in my own friend's submissions, to grapple with the fact that you do not imply a choice of law simply from a choice of seat. The second main error, if I may call it that, in my own friend's analysis on the proper law issue, is it starts from the wrong place. And when I say it starts from the wrong place, not only does it start from the proposition that a choice of seat is a choice of law, which I've already dealt with, but it also starts on the basis that you begin by ignoring the main contract and looking solely at the arbitration clause. Now, in my respectful submission, the correct place to start the analysis is the proper law of the main contract itself. And if that proposition needed any authority, it has the formidable support of Lord Mustle himself, and the reference is in the electronic bundle at page 6404. And if you go to 6403, you will see the heading of this section is the proper law of the arbitration agreement at 6404. In the middle of the page, after the three numbered paragraphs at the very top, Lord Mustle's book begins. The starting point is to determine the proper law of the contract in which the arbitration is embodied. My lord, that's the starting place, and my own friend's arguments effectively amount to having the tail wag the dog. If I can deal very briefly with the reasons said to support the analysis that the weight to be given to the seat should outweigh the weight to be given to the main contract. Firstly, as far as separability is concerned, my understanding of my learning friend's submissions was effectively not to support that aspect of the Court of Appeal's reasoning. And of course, if that is right, that fundamentally undermines Lord Justice Popperwell's analysis. Secondly, as far as neutrality is concerned, there was no attempt to grapple with the way Mr. Justice Clark dealt with it in Egon, or how Stephen Chong dealt with it in BCY. And as far as the Article 5.1a point is concerned, the fact of the matter is, again, there was no attempt to deal with the way it was dealt with in BCY. And perhaps I can just remind you how it was dealt with there, because it answers a number of the points that my own friend sought to put to you in argument. It's page 1225. And it's paragraph 64 of the judgment. And at the very top of page 594, right-hand column, you'll see that the learned judge says, the law that the parties have subjected the agreement to would include their implied choice, as Bourne observes, and he gives the references. Now, so far as the question of implied choice is concerned, I don't have time to take you to all the references, but I would refer you to, in addition to that, Merkin and Flannery, which is in the appeal bundle at his paragraph 103.9.3. The electronic bundle reference is 7601. And of course, my own friend Mr. Landau took you to the Unicrol guide to the convention yesterday, which was 7607 to 8. My Lord Burrows asked me yesterday about the default position of common law, and I did at that time as you know, based on the article I'd read first thing in the morning, suggests the possibility of a default rule based on Article 5.1a. Having reflected on the point, I was wrong to make that proposition, and I'd like to withdraw it. And I apologise for perhaps being tempted, having read the article that morning, to allow a half-baked thought to enter my submissions. That was a mistake, and I apologise.
I should think we've all been down that road, Mr. Bailey, at one stage or another.
Oh, my Lord, I'm obliged. My Lords, can I? I've got a few minutes. I've got 10 minutes left, and I want to try and just develop one submission, which in the ultimate analysis, represents what we say is the fundamental error in Enka's arguments. And this goes both to the choice of law issues, and it goes to the West Tankers case, which my own friend relies upon. And in our respectful submission, the fundamental mistake, or the misconception that lies at the heart of my learned friend's submissions, which undermines all of his arguments, is that it assumes that the only relevant choice that the parties make is the choice of seat. Now, the correct analysis is that the package of rights, as he calls it, the package of rights and obligations that apply in relation to an arbitration, depends upon, for its contents, the combination of choices that the parties make, especially in the context of choice of law and choice of seat. It's those relevant choices taken together in combination that determines the contents of the package that results. And the key choices they have to make, of course, are the proper law of the main contract, the proper law of the arbitration agreement, the seat, and the curial law. And you can choose all of those to be English. And of course, that's the West Tankers case. The paradigm case, all the choices were English. It was a full English, so to speak, case. What did they choose in this case? Well, it wasn't the full English, if I may put it that way. Sorry, there have been too many metaphors in this case, but there wasn't a full selection of every English aspect of the case. What did they choose in this case? They chose, firstly, Russian substantial law to govern the main contract. They chose a London seat, but they did so in context of an ICC arbitration, which imports the supervisory powers of the Court of Arbitration in Paris. They also chose the ICC rules, which override a number of the non-mandatory aspects of the 1996 Act. And they also, we would submit, as a consequence of that, ended up with a package of rights and obligations which are different to the circumstances that would arise simply by reason of a choice of London as a seat. There's also, as you'll see from the arguments in relation to sections 4.5 and 4.4, the consequences of a choice of law do have an impact upon the curial law that governs the arbitration. So in my respectful submission, once you begin to appreciate that there isn't a one-size-fits-all solution here, that by reason of choosing a London seat, everything follows. It's the combination of those various choices that impacts upon the result. And there are plenty of examples of this. For example, the potential effect on enforceability. One sees that from Kebab. One sees that from Dalla. Choices of law make an impact in that area. Secondly, it also has an effect on the non-mandatory provisions, as we've seen from section 4.5. And thirdly, in my respectful submission, it's a relevant element when you come to consider the exercise of the court's power to grant an anti-suit injunction under section 37. Party autonomy lies at the very heart of arbitration. But it's not the only choice they make, being the choice of seat. They make a range of choices. And it's the combination of those, including their choice of law, which can impact upon the circumstances and manner in which the court exercises its jurisdiction. It's never been my client's case that this court has no jurisdiction to grant an anti-suit injunction. It plainly does. The point about West Tankers was that was a case where everything pointed and every choice that had been made was an English choice. It's no doubt correct that Lord Hoffman said that by agreeing to the seat being in London, the parties were accepting the jurisdiction of the English courts. But that doesn't mean, in my respectful submission, that they're accepting that the exercise of the jurisdiction would be the same and not affected by the consequences of their other choices. Because in my respectful submission, West Anchors was a paradigm case of the full English. Every aspect of that case was English in the sense that the contract was governed by English law. There'd already been a finding of breach before it went to the House of Lords. The judgments given in that decision were guidance to the ECJ. That was the purpose of what Lord Hoffman and Lord Nance were doing, giving guidance in the hope that they would get a different answer to that came back in Turner and Grovitt. It didn't work out that way, but that was the hope. And it was all given in a context which is very, very different to the circumstances of our case. My Lord, I have a few references, a few moments left. I have a few references from Mr. Landau, which I could, if I could just pass them on to you, that are relevant to 4.5.
Yes, of course.
He asked if I could mention these references for you to look at in the bundle. They are references to Briggs at page 1407. This is in relation to the 4.4 point, and Merkin at electronic bundle 1564. As far as the points on Lesotho are concerned, there was no answer in my respectful submission from my own friends about the Johnny Vida article. But moreover, that is the view that has the weight of authority behind it. And I'd particularly refer you to the passage in Merkin and Flannery, the electronic bundle references of 1564 to 1567, which deal with that point we would submit conclusively. But, my lords, at the end of the day, one is faced with a situation, perhaps unusually, which in our submission has simply not arisen for decision in this country yet. And Judge Rakoff's approach, in our respectful submission, has the elements of simple commercial reality to it, and we would commend it to your lordships as the appropriate approach to adopt.
Yes.
Is one problem with Judge Rakoff's approach, sorry, Mr. Bailey, that in this case, if I've understood it correctly, the merits of the dispute are being decided in parallel with the arbitration validity point. So it's not just a matter of waiting to see whether the Russian court decides on the validity of the arbitration agreement, but you're going to get a decision on the merits at the same time, aren't you? Which is what if the arbitration agreement is valid, you're trying to avoid.
Well, my lord, we're only going to get a decision on the merits if the Russian court decides that the dispute pending before it does not fall within the scope of the arbitration agreement.
Yeah, but when it delivers judgment, will it just be on the arbitration point, or will it be on both points?
Well, my lord, I can't be certain, but clearly I would recognise the fact that there's a good prospect it would be on both.
Because the previous decision was on both, wasn't it, at the same time?
I agree, exactly why I've just said I think it could be well both. My lords, I do see that point, of course I do. But as I mentioned the fact that the two are being heard together, and the judgment on the merits will only arise if the Court of Appeal affirms the judgment below in relation to the Russian law issues to the scope of the arbitration agreement. Because by definition, if the Russian law point is decided in Enka's favour, the merits will not fall for decision because there'll be a stay under Article 2.3.
Yeah.
Okay.
Good. Well, thank you very much indeed, Mr. Bailey, and thank you, Mr. Dicker, and of course the other counsel who have either Mr. Landau presented orally and those who have assisted in the background. Very interesting case, not an easy answer, but we'll do our best to produce it as quickly as we can. So thank you all very much indeed. Thank you. Court is now adjourned.